Hello friends, welcome to my channel. Today's video is about Supreme Court's judgment. Three important Supreme Court judgments pronounced today. Today means not today, Monday, February 4, 2019. So today is February 5, Tuesday. Okay, so I'm following a website for this purpose. It's not my own blog. So here, number 1, State of Madhya Pradesh versus Kanha at Om Prakash. What happens in this case? The Indian Penal Code 1860, Section 307. So we already know Section 307 is about attempt to murder. Okay, the lack of forensic evidence. So this is the subheading of this article. Indian Penal Code, the Indian Penal Code 1860, Section 307, attempt to murder. The lack of forensic evidence to prove grievous or a life-threatening injury. Lack of forensic evidence to prove grievous means a serious kind of or a life-threatening injury cannot be a basis to hold that Section 307 is inapplicable. So here we can see, if we read this second paragraph, we will learn that the evidence established that the injuries were caused by firearm. The multiplicity of wounds indicates that the respondent fired at the injured more than once. Respondent means the person against whom allegations has been brought about, and respondent fired at the injured person who was injured more than once. The fact that hurt has been caused by the respondent is sufficiently proven. Okay, the fact that hurt has been caused by the respondent has caused a hurt, it has been sufficiently proven because of the multiplicity of wounds. You can focus on these words, multiplicity of wounds. Okay, these words, multiplicity of wounds. These things prove that it was intentional. It was an intentional. And as we already know, for the criminal offense, intention is an important element. The Indian Penal Code 1860, Sections 147 and Section 307, read Section 149 and Section 323. Attempt to murder. Proof of grievous or life-threatening hurt is not a sine qua non for the offense under Section 307 of the Penal Code. The intention of the accused can be ascertained from the, so here this line is very important, the intention of the accused, because we all know that for the purpose of criminal offense, intention, that is menstrual or guilty mind, is an important element, which is a mental element and essential element for criminal liability. So the intention can be ascertained from actual injury, if any, as well as from surrounding circumstances. You can focus on this word, see here, surrounding circumstances, the circumstances, and also actual injury, because in this case there were multiplicity of wounds. Means indicates that the respondent had, it indicates the menstrual, which is guilty mind. So the intention of the accused can be ascertained from the actual injury, if any, as well as from surrounding circumstances. So here two words are important: actual injury and surrounding circumstances. Among other things, the natures of the weapon used and the kind of nature of the weapon used, and the severity of blows, how many blows were given, inflicted, can be considered to infer intent. So of course, we know that intention is an important element, but it is very difficult to ascertain because nobody knows what's going on another person's mind. But it can be ascertained from the surrounding circumstances, from the injuries caused, and also weapons used, and severability of blows or multiplicity of wounds. These are certain things from which an intention can be ascertained. In the present case, the nature of the injury shows that there were 11 punctured wounds. 11 punctured wounds. The weapon of the offense was a firearm. The circumstances of the case clearly indicated that there was an intention to murder. Circumstances, the surrounding circumstances of the case. The presence of 11 punctured and bleeding wounds, as well as The use of firearms. The use of firearms was, this was the kind of weapon used for the purpose. Leave no doubt that there was an intention to murder. Thus, the second part of section 307 of the penal code is attracted in the present case. So the case number is CRL.A. This is the case number. Petitioner's advocate, respondent's advocate, man's honorable justice, judgments by honorable justice. Okay, so I am going to give the link of this website in my YouTube description box. Okay. So, 2. Federation Trust Plot of India versus Union of India. Federation Trust Plot of India versus Union of India. Policy decisions of the executive are best left to it, and a court cannot be propelled into uncharted ocean of government policy. So, Federation Trust Plot is title. This is Federation Hospitals of India versus Union of India. Policy decisions of the executive. Executive, we know executive. This is the executive are best left to it, and a court cannot be propelled into the uncharted oceans of government policy. Public authorities must have liberty and freedom in framing the policies. Public authorities means to those executive administrative authorities have liberty and freedom, liberty as well as freedom in framing the policies. So court cannot intervene in those matters. It is well accepted principles that in complex social, economic and commercial matters, decisions have to be taken by the governmental authorities. Okay, what kind of matters? It may be complex social, economic and commercial matters, and the decisions can be taken by governmental authorities, keeping in view several factors. And it is not possible for the courts to consider competing claims and to conclude which way the balanced tilts. So, of course, courts are ill-equipped to substitute their decisions. Court cannot interfere in the policy-making activities of the executive bodies or officers of the government. It is not within the realm of the court to go into the issue as to whether there could have been a better policy, and on that parameters direct the executive to formulate, change, vary, and to modify the policy which appears better to the court. Such an exercise is impermissible in policy matter. So the fact is that judicial is entrusted with the task of interpretation of statutes, okay, and executive makes the policies of the government, implements those policies, and legislature makes or passes bills in the parliament or state legislatures. So in those cases, Supreme Court or any court judicially cannot interfere, or they cannot direct the policy on that parameters, direct that executive to formulate, first of all, to formulate or to change or to vary or to modify the policy which appears better to the court, because this is not the function of the judiciary or the court. Such an exercise is permissible in policy matter. Impermissible means it cannot be permitted. The scope of judicial review is very limited in such matters. So we know the judicial review. Judicial review is the power of judiciary to declare any act or laws, bylaws, orders, rules, or anything, act of executive as well as the act of legislature, to as ultra-virus, invalid, inoperative, or against the constitution if they violate any provisions of the constitutions, because in India we have constitutional supremacy and not parliamentary supremacy. Okay, so every statute, acts, laws, bylaws, orders, rules must stand the test of constitution. So here so executive to formulate, change, vary, or modify the policy which appears to better to court. Such an exercise is impermissible in policy matters. The scope of judicial review is very limited. Now at present the scope of judicial review is very limited in just matters. Just matters means those kind of executive policy making activities. It is only when a particular policy decision is found to be against a statute, or it offends any of the provisions of the constitution, or it is manifestly arbitrary, capricious, or malefic, the court will interfere with just policy decisions. In what cases court can interfere? Now here in the first part we find that court cannot generally interfere with those matters. It is impermissible. But we have to again consider that in what cases the court can interfere. It is only when a particular policy decision is found to be against a statute. If a policy decision is against a statute, statute means act of parliament or act of state legislature or anything, or it offends any of the provisions of the constitutions. It offends any of the provisions it is against, or in contrary or in violations of any of the provisions of the Indian constitutions, or it is manifestly arbitrary. Arbitrary means unreasonable, not just, capricious, or malafide. Malafide means with bad intentions. The court will interfere with such policy decisions on in those cases. So this is a case number. This is the petitioner's advocate. Bans Honorable Mr. Justice. Judgment by Honorable Mr. Justice A. Case agree. So after this another case, case number 3, Ramland versus Salig Ram. The Code of Civil Procedure 1908, Section 75. Order I don't know XXV. The Code of Civil Procedure 1908, Section 75. Order 26. Rule 10.3. If the local commissioner's report was found wanting in compliance of applicable instructions for the purpose of demarcations, if the local commissioner's report, commissioner's report was found wanting in compliance of applicable instructions for the purpose of demarcation, it was only a matter of irregularity and could have only resulted in discarding of such a report and recovering a fresh report, but any such law by itself could have neither resulted in nullifying the order, recurring appointment of local commissioner, and for recording a finding after taking his report, nor in dismissal of the suit. So it's only an irregularity and not any kind of recording file could have only resulted in discarding of such report. Recording fresh report but just law it by itself could have neither resulted in nullifying the order, recording appointment. Okay, the order is still valid, it's just irregular. What again? It just okay. Irregular. This is Code of Civil Procedure 1909, Section 76. The order made under this under Rule 10.3. Hence, were unable to approve the approach of High Court, whether after rejecting the Commissioner's report, the High Court straightway proceed to dismiss the suit. The plaintiff have been asserting encroachment by the defendant or their land. Okay, the plaintiff and plaintiff have been asserting encroachments by the defendant or their land and have also adduced oral and documentary evidence in that regard. As noticed, the first appellate court had allowed the appeal and the decree. Thus, they decreed the suit filed by the plaintiff not only with reference to the Commissioner's report but also reference to the other evidence to the parties. Unfortunately, the High Court appears to have overlooked the other evidence to record. Okay. So, okay, these are the 3 cases. 3 judgments pronounced in February 4, 2019. This is the website I am following. I'm going to give the link of this website in my description box, the YouTube description box. And thanks for watching. Please do not forget to subscribe if you like my videos, and please comment and give feedback. Thanks for watching. And this is not my blog, okay? Thank you.